Hello and welcome everyone. It's 2 p.m. here on the East Coast, so we'll get started. My name is Shannon Mead. I'm the Director of Labor and Workforce Policy and Government Affairs Division here at the National Restaurant Association. I'm joined today by my esteemed colleague, Mr. Angelo Amador, who's the Executive Director of the Restaurant Law Center, who's co-hosting with me today. We want to welcome you to the webinar presentation on immigration in the wake of the administration's immigration executive orders and the heightened enforcement actions. Please note we are recording the webinar today. This presentation will be made available along with related materials on our website at www.restaurant.org/webinars in approximately 1 to 2 business days. But for those who are participating today, there will be a link provided directly to you after the webinar so that you will have that. Now, to kick things off, I'm going to turn it over to Angelo to make the introductions of our presenters.
So you have their bios, and the bios are going to be online as well, but I want to have the great pleasure of introducing Becky Young and Rachel Zoghlin. Is that how you pronounce your last name? Great. I know Becky for many years, and literally somebody that I would recommend to anyone. She started the Hammond Young Immigration Law Firm, where she heads the hospitality group. We have actually gone to restaurants together and talked to chefs and others that she have brought with employment visas. So again, you know, she's going to be presenting from the perspective of employers, and Rachel, her practice concentrates more on the workers and the employees and a number of other visas. I'm not going to go through the whole alphabet, but UTs and others that she represents. So we are very lucky to have them both here. You're going to have their contact information as part of the presentation. But with that, Becky.
Thank you. I think Rachel is actually going to start off by speaking about the executive orders that were put into place a few weeks ago.
Yeah, so unless you have turned off the news completely, everybody's probably aware that about a month ago, shortly after the president was inaugurated, he issued a series of executive orders making good on many campaign promises that he had made over the preceding couple of months. So there are two that are kind of in my wheelhouse, and then Becky will talk about the third one. The first one, we've got the slide here, enhancing public safety in the interior of the United States. The purpose of this, again, he's fulfilling campaign promises and trying to address what the priorities will be or what the future policy will be to come, through the executive agencies, so through the Department of Homeland Security and the Department of Justice. A couple of the big points from this executive order are that what the new priorities will be for removal. So President Obama had in 2014 pronounced that made very specific who the Department of Homeland Security would be focusing their limited resources on trying to remove. And at that point, in 2014, he was really focused on people with pretty serious criminal records, people who are recent entrants, so they were looking at folks who had been here from 2014 and sooner, and that was really it. People who had been ordered removed from 2014 sooner. Now,
so those were Obama's priorities.
that was in the 2014 Obama priorities. Now, in this January 25th executive order, President Trump is directing his agencies to revisit those priorities. So the new priorities for removal are basically any undocumented person, and it really broadened the definition of criminal, what they say, criminal aliens or criminal non-immigrants. And I'll go through a little bit more detail when we talk about the implementation memos that were released last week. But this is really ramping up enforcement, so it's casting a much wider net on who is removable. He's authorizing the hiring of many more ICE agents, so people who are tasked with enforcing the immigration laws, both from a police and law enforcement end as well as a prosecutorial end. withdrawing the federal funding for sanctuary cities. So many cities across the country have said that they are not going to work with federal immigration officials to either detain initially or to hold on to people who are in criminal detention who could be turned over eventually for immigration enforcement, or to refuse to kind of collaborate with immigration agencies on, in immigration status or other bases of removability potentially. And it's kind of related to this last point here, empowering state and local law enforcement to enforce federal immigration laws. So not just removing, threatening to remove federal funding from cities that are trying to kind of protect their immigrant population, but to take that a step further and to empower state and local law enforcement officials effectively to deputize them to enforce federal immigration law. So I'll talk a little bit more about that when we get to the implementation memo that was issued last week.
I think actually right before the webinar we were talking about some raids that supposedly had happened over past week or past weekend in some parts of the country. And do you think that they might have been related to this executive order and local law enforcement enforcing the immigration?
Yeah, I think it's highly likely. I think that we can talk. I think we should revisit this conversation, but it'll be more. When we're talking about the executive orders, this is really just President Trump saying these are what my priorities are going to be. These are what I want my agencies to do, and then it's going to be. It's up to the agencies really to get down to the nuts and bolts of it and say, okay, here's how we're going to work these priorities. Here's how we're going to do this, actually. So DHS Secretary Kelly last week came out with a couple of implementation memos that relate to these executive orders, and I think there's a couple relevant points that are more detailed on that slide. But to talk about the next, we can go to the next slide. Sorry, or go back one. Sorry. And then the other big of the three big executive orders that came out on the 25th was border security and immigration enforcement. So obviously this is the wall that has been talked about for a long time. There had been a policy of what's called catch and release for people who are apprehended near the border, particularly people who are seeking asylum, in part because the backlog in immigration courts where all of these people who are being apprehended at the border are applying for asylum, it can take from 3 to 5, and I've heard some places 6 or 7 years until the process is completed. The idea with catch and release is that we don't want to detain them for 7 years while they're waiting for their hearing. But I think part of the executive order is to say, well, we don't want to release them because we haven't done enough background checks on these people. We should detain them and then also try to expedite their asylum hearings. So if we can do both of those things, that would be ideal, I guess. And then the hiring of more agents, more people on the border to enforce, on the enforcement side. So these are going to be the police. These are going to be the border Customs and Border Protection officials on the border. And then this last point, again, he talks about it in both executive orders, is empowering and deputizing state and local law enforcement to serve as effectively immigration officers. We can go to the next slide. So last week, DHS, Department of Homeland Security Secretary Kelly issued 2 major implementation memos. So discussing these last 2 executive orders from Trump that I just mentioned. The first one on enforcement of the laws for the national interest. This goes into a little bit more detail about who the Department of Homeland Security is going to focus their resources on removing. So in addition to the folks that were mentioned in the kind of painted with a broad brush in the executive order, any undocumented person and, any quote-unquote criminal aliens, they say they're going to prioritize, of all of these people who they're prioritizing they're especially prioritizing these new removal priorities, including any person who is removable who has been convicted of any criminal offense, who's been charged with any criminal offense and the charges have not been resolved. So this is someone who could be in the middle of criminal proceedings currently, and the case has not been resolved. It could ultimately be resolved that they're not guilty, but they're presently in, if they're in unresolved criminal proceedings, they are now a DHS removal priority. People who have committed acts which constitute a chargeable criminal offense. So this would include people who either have admitted to committing something and they were either never charged later, or they took a plea deal and pled guilty to something else. If they admitted to committing acts that constitute a chargeable offense, they are now an enforcement priority of the Department of Homeland Security. Anybody who has engaged in any sort of fraud or willful misrepresentation and before any governmental agency, this used to be really focused on immigration fraud, but now it could potentially be much broader. Anybody who, in the discretion of the Department of Homeland Security, is deemed to have abused any public benefit system. So that could include food stamps, it could include public health care, just to name a few. Could it possibly include kids getting free school lunch? I mean, it's not clear, I think, yet. That's to be determined. Anyone who's subject to a final order of removal, this is a very big change from Obama's 2014 priorities, because he had said people with very old orders of removal who have been here for a long time are no longer priorities. This is going to include a lot of people who have outstanding removal orders. Or, and this is kind of the catch-all, in the judgment of an immigration officer, pose a risk to public safety or national security.
And that's pretty broad language, isn't it?
That's especially broad once we look at this second point, reauthorizing 287G agreements. These are the agreements that allow state and local law enforcement, so just your local Sheriff Joe, to act as immigration officers, so to investigate, to identify people who might be removable, to arrest them, to detain them, and really just to pass over anyone they suspect could be now removable. So if we look back at this first bullet point, anyone, if they think someone who has committed acts which constitute a criminal offense, jurisdictions that now have these 287G agreements, these local law enforcement officers are empowered to make these arrests and pass these people over to immigration authorities. We were talking a little bit before this, as Becky mentioned, before we went live here, about a couple, some of the raids that have been happening in restaurants across the country. And Becky said, could this be because of this 287G? Could this be because of these local law enforcement officials who are now empowered to kind of make these immigration calls? And I think it's highly likely. I had it written down on the computer, and if this actually has, I don't know if it includes my notes. It might not. No. I had it written down before. I don't have it in front of me, but there's something. 32 law enforcement agencies in 16 states currently, which have 287G agreements. You can, assuming that DHS updates that website, you can check to see if the jurisdiction where you live is subject to these 287G agreements. The local jurisdiction, the local government, to engage in this will have to create what's called a memorandum of agreement, an MOA or MOU, memorandum of understanding, with the Department of Homeland Security in order to be considered a 287G jurisdiction. And what used to happen, I don't know what the future holds for this, is that there would be some sort of training for the law enforcement officers on what it means to be a 287G jurisdiction, what it means to be deputized as an immigration officer. I guess we'll see. I think it's a little bit too early to tell how, whether that process is going to be the same. But that's to be determined. As far as prosecutorial discretion, just as in any sort of criminal setting, the ICE prosecutors had discretion to initiate removal proceedings against non-citizens who they deemed to be removable from the United States, just as a state or a federal prosecutor has the discretion to decide when and what kind of charges they're going to bring against a person accused of a crime. This implementation memo highly discourages that use and really basically says to the ICE prosecutors, anybody who's removable, we shouldn't be exempting any special classes of people from removability if they're removable. So we should really be going after all of them.
Rachel, if we can go back to the state and local law enforcement, I think there's an example that came up a lot in my practice after September 11th, when state and local law enforcement were vigorously involved in enforcing the immigration laws. And this is just one example, but I think it's important, which relates to visas. So a visa is actually a stamp that you get in your passport, and it allows you to present yourself at the border outside of the United States. So your visa loses all relevance once you're in the United States. But there were multiple instances of people being picked up and detained because they had expired visas. So I think that illustrates, it's important factually to understand, there's one issue about people who maybe are properly detained under these provisions, but then there's going to be an entire different category of people who are not even supposed to be covered by these orders. But if state and local law enforcement isn't clear on the significance of a visa, for example, and there are many other examples, people could be detained. People could be detained improperly. So that's a concern.
Yeah, I think, the political climate is certainly, over the past several years, been moving towards, publicizing more and talking more about people, perhaps being accused, people being detained, being profiled based on perhaps the color of their skin, perhaps of their perceived nationality. This was an issue that came up and actually went to the Supreme Court a couple of years back when Arizona passed a pretty restrictive, state laws that had included some sort of, punishment for what were perceived immigration infractions. Part of the issue there was that, a lot of people who were caught up in these, state crimes in Arizona were people who looked Latino. And they were saying this was, it's racial profiling, it's discrimination based on race, on perceived nationality, on national origin. And I think that there's going to be more, there's certainly going to be more of that conversation to come as 287G jurisdictions are now reauthorized, and I can only imagine will be proliferating over the coming weeks and months. And we can go to the next slide, I think. If people have questions, we can talk about it after. Oh, this is the other implementation memo, sorry. The Border Security and Interior Enforcement, so this is also where they talk about the wall. In this implementation memo, DHS Secretary Kelly authorizes hiring, again, many more Border Patrol officers. He announces the plan to use what's called expedited removal. So in the past, this has been a tool to kind of more quickly process individuals who were apprehended within, individuals who were apprehended within 100 miles of the border who could not prove that they had been in the U.S. for more than 2 weeks. And they call it expedited removal because these people are basically removed from the United States without any sort of removal hearing, without any sort of, really any due process, unless they expressed a fear of returning to their home country or they could prove presence in the United States for more than those 2 weeks. Now, in this new implementation memos, DHS Secretary Kelly announces that they have plans to expand the use of expedited removal. They haven't authorized this yet, and he says this will be active upon the publishing of a notice in the Federal Register, which effectively starts agency rulemaking. But what he has said in this memo and what people have been talking about as far as expedited removal is that they plan to initiate and execute removal of individuals who either don't express a harm, or either they express a fear of returning to their country, they don't express a fear of returning to their country, or they express a fear of returning to their country that they don't determine is credible, which you'll see on that bullet point number 4 there, or who cannot prove that they've been in the United States for at least 2 years. So that really dramatically broadens the number of people who could be subject to expedited removal, particularly if they're going to be detained throughout this process. It might be difficult to prove that they've been here for 2 years. This also will, they're authorizing the detention of recent entrants. You'll see this already. There's been a pretty substantial expansion of detention facilities, particularly along the southern border of the United States. The U.S. government has revisited and reauthorized contracts with private prison industries again to be able to house more immigrant detainees. On this 4th point, they're heightening standards for credible fear determinations for asylum seekers. So typically, if an individual is apprehended in the United States without authorization and they express a fear of returning to their country, they are offered what's called a credible fear interview. So it's basically a non-adversarial, supposed to be non-adversarial interview with an immigration officer, at which point they explain why they're afraid to go back to their country, and the immigration officer determines whether it's possible that, based on what the person had just explained in their interview, whether it's possible that they could establish their eligibility for asylum relief in a full hearing. That credible fear process in the past has been a pretty liberal, the standard has been pretty liberal. And the reason for that is because the immigration officers are not, they're not lawyers. They're, coming from the same agency that is later to be prosecuting people for deportation. So the idea is, if this is a person who, if at any chance, if they're going to get a lawyer or not, if they go before a judge who's a neutral arbiter, could be determined to qualify for asylum protection under our laws, they should have a chance to do that. Now those standards are going to be much higher, which could really negatively impact people who could legitimately have legitimate asylum claims, who might not be able now to present them. I mentioned already expanding the detention centers of the U.S.-Mexico border, and this last one, discouraging the use of parole unless for an urgent humanitarian reason or a significant public benefit. And this is for either people who are presenting at the border saying, I'd like to apply for asylum, or people who are here within the United States, depending on what type of immigration status they hold, could be eligible. They would have to, these are people who are not lawful permanent residents, but are asking for permission to travel outside of the United States and return back, or in other ways be eligible for immigration relief inside the United States. This parole has allowed thousands of people to kind of fix their immigration status, so to speak, through other alternatives that was not available to them previously. So this discouraging of the use of parole, I think we're going to see is going to really impact a large cross-section of the immigrant community who are not lawful permanent residents but have other sort of recognized immigration status.
Okay, so we're going to talk about the 3rd executive order that came out a few weeks ago, and this I think is probably the one that, I don't know, they all got a lot of press, but this one seems to certainly have been the most challenged in the courts. Before we do that, I wanted to roadmap our presentation for you. we wanted to start off with sort of the landscape of what's been happening legally as context for these actions and how they're relevant to employers in the restaurant industry. So after we talk about this last executive order, Rachel will spend a few minutes talking about how we believe these orders will impact restaurant employers and their employees. And then we're going to talk about enforcement actions. So we've talked about raids, ICE raids that have been happening throughout the country, but there are also other types of enforcement actions that we may expect in the coming months. So we will outline those for you. And then finally, we'll end with some information about what you can communicate to your employees and what you can do if you want to, speak out about any of these issues, if you have opinions about them. So with that, let's talk about the January 27th order. So this was the order that came out on a Friday, and it has two main components. The first component is what President Trump referred to during his campaign as a Muslim ban. So it targets nationals of 7 countries: Syria, Sudan, Somalia, Iraq, Libya, and Yemen. And it does 3 things with regard to these populations. The first is that it precludes them from traveling to the United States. The second is that it precludes them from receiving a visa for travel to the United States. And the third is that it precludes them from receiving a benefit, such as an employment authorization document, asylum, H-1B visa, or H-1B status, I should say. At this time, this particular provision is not being implemented. It was implemented for about a week. It caused some chaos, for lack of a better word, at airports around the country. When it was implemented, there were people in flight, and many of them were detained upon entry. There were some legal permanent residents who were detained upon entry. There were reports of legal permanent residents being asked to give up their green cards, being forced to give up their green cards. So there was a lot of publicity that surrounded the implementation of this ban. It was challenged in numerous courts, and as of today, the Ninth Circuit's decision is still has this portion of the January 27th executive order on hold. So it continues to be litigated. We expect a new order on this point any minute now. It was promised last week. It was postponed until this week, but I would think that sometime this week we'll see a new order addressing this point, and probably drafted more narrowly to address the concerns of the Ninth Circuit. The second part of the January 27th executive order, which is still in effect, relates to refugee admissions. So this does 3 things. The first is reducing the overall admission numbers for refugees to 50,000. The second is suspending all refugee admissions for a period of 4 months, 120 days, and indefinitely suspending admissions of Syrian refugees. That is significant since of the 60 million displaced people in the world, Syrians make up one of the largest, if not the largest populations. And then the third point about the refugee restrictions in the January 27th executive order is that it prioritizes persecuted religious minorities in refugee admissions. That last provision has raised a lot of controversy, and I certainly expect it will be litigated. Okay, so let's turn it over to Rachel, who will talk about these executive orders and what, practically speaking, we think they will mean for restaurants.
Thanks, Becky. So if any of you all on the call have employees who are immigrants, they could hold various forms of immigration, lawful immigration status in this country. Not everybody, you don't have to be a green card holder, you don't have to be a lawful permanent resident in order to work. There are many people who have work authorization on other bases. So just talking about people who are lawful permanent residents, these are the folks who have green cards. They have the right to live and work in the United States permanently unless they are removable for a number of reasons, the biggest of which is for serious criminal, pretty serious criminal activity. But certainly people who are lawful permanent residents are subject to fewer grounds of removability. The kind of criminal activity that would get them into trouble is usually a little bit more serious than people who are not lawful permanent residents. But if you have employees who are lawful permanent residents, just because they have green cards does not necessarily mean that they're in the clear. People who have green cards who have criminal histories, particularly if people have whoever had what's called a PBJ, a probation before judgment, these are not typically considered, especially by criminal defense attorneys, to be criminal convictions. So if you have an employee, or if you know, you might not know, if they have ever been in criminal trouble, these people might not think that they have a problem because they did probation, it wasn't on their record, might have been expunged, it might not exist in a criminal history search. A probation before judgment is still considered a conviction for immigration purposes, and particularly now that having admitted the elements of a crime makes someone removable, this could get people into trouble. Usually for probation before judgment, you have to admit basically that you committed the crime, and you do probation beforehand, and then they basically don't convict you. The probation kind of negates it. But the fact that you admitted to the elements of the crime beforehand is what gets these people in trouble. So folks who have really any sort of criminal record, even if they are permanent residents, will want to talk with an immigration attorney to make sure that their status is safe. But definitely, I think folks from the 7 affected countries, we've heard of a lot of people encountering issues returning home from travel abroad. Even people, if they have dual citizenship, we've heard of people who hold dual citizenship. Maybe they're a green card holder here. They could be a dual citizen of, for example, Canada and Syria. Their Syrian citizenship, even though they should not be barred entry at this time, they could be what's called referred to secondary inspection at the airports, and they could be detained for several hours before being allowed into the country. Or like Becky said, we've heard a lot of people being coerced or forced into signing what's called the I-407, which is basically voluntarily giving up your green card. And
actually, if I can interject about that, and by the way, there's a question, do green cards expire? The answer to that question is yes. Green cards are valid for 10 years, and so you are required to extend your green card if it expires. There are some very, very old green cards that do not have expiration dates on them. It is recommended that individuals with those old cards get new cards. If you don't renew your card, you're still a permanent resident. You don't lose your status by failing to renew the card, but you don't have any proof of it, and there is actually a law which says that you're required to carry your green card on your person, so it's hard to carry it on your person if you don't have it. But going back to the point that Rachel was making about the I-407 and Rachel's third point here about issues returning home after travel abroad. So we encounter a lot of permanent residents who think that they can sort of come to the U.S., live overseas, and come to the U.S. every 6 months or so and keep their green card. And that's not legally correct. And so I think that, as customs becomes more vigilant, certainly individuals who are residing overseas and only sort of from time to time stopping by the U.S. to say hello may be asked to sign an I-407 and give up their green card at the border. So that's actually not a change in the law, but it is a change in enforcement, which I think we'll see.
Yeah. that's the other catch about the lawful permanent resident thing is it's lawful, it's permanent unless they take it away from you, and it's for residents, so you do really have to live mostly here to keep it. Many folks here on the call may have employees who are not green card holders but have other forms of lawful recognized immigration status. I couldn't list them all for you because there are many, many different types, many ways that you can get a work permit or an employment authorization card that's not because you have a green card, obviously. These folks are going to be subject to different bases for removability than green card holders are. They have less rights before immigration agencies than green card holders do, and certainly a lot less rights than U.S. citizens do. For these people, travel abroad can be more complicated in the first place, but it's certainly, I would say, it will be more complicated now. And these people, I think, it's highly likely these are the type of people who may encounter issues coming back once they've traveled abroad. Another thing that they'll want to keep in mind is that, not related to the travel ban, but just in general, there have been the immigration agencies are changing the way that they process renewals for employment authorization. So if you have folks who have presented their employment authorization document as proof of their lawful status to work in this country, if you can check the expiration dates. Typically, they are allowed to and should renew their employment authorization a couple months before it expires. Now, the immigration authorities are saying, they used to say, we promise we'll do it within 90 days. Just file your renewal, about 3 months before it expires, and we'll get you that, approval and your new card within 90 days. Now they're not holding themselves to that 90-day deadline. So if folks have work authorization, it's likely they want to look into filing those renewals sooner. However, that's something for the employers to note is that there are several bases upon which people have work authorization that as long as you file for the renewal, it'll be automatically extended for 6 months. So hopefully within those 6 months, your employee will get their new card and there wouldn't be a lapse in employment there. But to keep in mind that there are expiration dates on these cards. It's going to be a little bit more cumbersome now to renew them. And for some, but not all people who have work permits, it'll be auto-extended while the renewal is processing, but for many people it won't be.
So Rachel, I'd like to hop in and talk a little bit about, you've brought up travel for lawful permanent residents and travel for foreign nationals who are not in lawful permanent resident status. There have been some issues that have come up in our practice, which are relevant to, frankly, all travelers to the United States, including U.S. citizens, and those are issues relating to search and seizure at the border. So I think this particular issue is probably less relevant to your rank-and-file restaurant employee, but certainly relevant to restaurant owners and executives who are traveling overseas with their work laptop, their work BlackBerry, their work cell phone. Regardless of your immigration status, you do not have Fourth Amendment rights to the data on your electronic devices when you present yourself at the border. So there have been several highly publicized incidents of U.S. citizens as well as other individuals who have had their devices seized. They were asked to provide passwords for those devices, and ICE does have the authority to both look at your data and potentially seize your data. I believe that they are required to have a reasonable suspicion to seize your devices, but they do not have to have they can absolutely inspect your devices and look at your data without any suspicion. So just something to be aware of if you're traveling with confidential company or personal data at the border these days. That has been an increasing issue that we've seen. Also, just want to touch on this one question, which goes back to our earlier discussion. So as an employer, what are our exposures to employing an immigrant who suddenly qualifies for deportation under the new orders? So we're going to get to enforcement actions in a moment. At this point, I would say, the legal liability has not changed. The enforcement regime has not changed, but the chances of any one of these types of enforcement actions occurring at your place of work has increased. We don't know how much. The situation is unfolding, but certainly, the likelihood that ICE might show up at your place of work and identify employees who are subject to removal, that the Department of Labor might show up to look at your labor documents, et cetera, those are all increased in the current climate.
I would say as a practical matter, if one of your employees is being subject to removal proceedings, and they have lawful status when you hired them, they for the most part would continue to have their lawful status until a judge, especially for green card holders, they would have to go through what's called rescission or removal proceedings. So they would continue to hold their green card until it's effectively taken away from them. For the most part, most of the folks who have employment authorization, maybe not most, maybe some of the folks who have employment authorization, other employment authorization that are not lawful permanent residents, their employment authorization could be terminated by DHS before they're put into removal proceedings, or they could continue to hold employment authorization while they're in removal proceedings, and then that would be resolved kind of at the conclusion of removal proceedings. So as far as an employer who's concerned about whether the person has status to work, it would really be on a case-by-case basis. The other thing to keep in mind is if someone is subject to removal proceedings, they could get picked up by ICE. And ICE is now going to be authorized to detain these people throughout, at least until the case goes before the immigration judge. So I think Becky and I are going to talk about that in a little bit, but one issue that you as an employer might face is the fact that your employee might get picked up and arrested and detained by ICE, and how long that might be.
Right. And there's a question here. I suspect that many others might have similar questions. This particular question relates to an employee who has an old deportation order. He's now married to a U.S. citizen. He's concerned about that because he's working under his real name, that ICE agents may come for him. And the employer is asking what they should advise him. I think what they should advise him is to speak to an immigration attorney, because each case is very fact-specific. This particular type of case is more within Rachel's wheelhouse than mine, but I can tell you that, based on those facts, there could be many, many different possibilities. But now, if this person has not spoken to an immigration attorney, now would be the time to do so. He may have a way to regularize his status. He may have options that he doesn't know about. But each determination is very factual.
The follow-up question there was, since he had this deportation order from a long time ago, wouldn't they have come looking for him, before now? And the answer is no. Under Obama, especially, over the past couple of years, from 2014 to 2017, these people with old removal orders are not removal priorities, unless they, had criminal issues, basically. Obama said, look, these are people who are parents of little kids. These are people who have been here. They're part of our community. And these are not, we're not going to, the Department of Homeland Security has limited resources, and we want to focus the money that our agency has on supporting the people who are a danger to our society. That's no longer the case. Now everybody, now I would say that person's employee should be careful. If you have an old removal order, I heard someone really grotesquely, that an ICE officer really grotesquely said something like it's hunting season or it's open season. These people are very vulnerable. So yeah, I'd like to repeat what Becky said. He should find a reputable immigration attorney. There are a lot of people out there who take advantage of immigrants because they are in such vulnerable situations. There are a lot of people who purport to be attorneys who are not attorneys. So I would say, maybe the best thing you could do is help your employee find a reputable immigration attorney.
And let me reemphasize that point. it is hard for us to tell you what to tell the employee. What you should tell the employee, as we just said here, is ask them to get an attorney, particularly, they've been here 10 years, they're married to a U.S. citizen, they have U.S. citizen children. I mean, there's a number of visas and there's a number of ways that you can regularize his status. It's not easy, and it's not something that they would probably be able to do on their own. So the best that you can do is to tell them, if they have all of those things going for them, they should talk to an attorney that will be able to explain what a number of different options. Again, there's an alphabet of visas out there that might be available.
Are we going to this question here, or are we going on?
No, you can go.
Okay. To move on, if you have employees who are immigrants and refugees, especially if they're from one of these 7 countries, even though the travel ban is kind of halted at this point, if they travel abroad, they could still encounter issues coming back through the airport. They're not supposed to. The airport officers, the Customs and Border Protection officers are not supposed to turn these people away, but from what I hear, these folks are still getting put into secondary inspection and still being detained upon reentry. So if you don't need to travel, I would tell if people don't need to travel abroad, I wouldn't. Obviously, don't get arrested. Getting arrested would be, really bad for people's immigration status. Try not to be involved in criminal stuff. That would be obviously
bad for everyone. But
yeah, that's good for everyone.
It's good advice for life.
Related to that, and this is kind of a point that I had mentioned before, accepting or pleading guilty to criminal convictions before consulting with both a criminal defense attorney and an immigration attorney. A lot of times the criminal defense attorneys don't know the immigration consequences of criminal convictions. And it's very, very often that there would be a plea to a certain criminal activity that a criminal defense attorney might think would be worse, like the person would spend more days in jail, for example, but plead to a lesser crime. The criminal defense attorney's instinct is usually to keep their client out of jail as much as possible. Those are sometimes in tension, and so, a non-citizen really needs to speak with both a criminal defense attorney and an immigration attorney if they're faced with criminal charges, to be very, very careful about their future status in this country. And this last point only applies to asylees or refugees, should not be renewing their passport from their country of origin. That might seem strange for people who are not in the immigration world, but when you are seeking asylum or when you have asylum or refugee status, you're basically saying that your government can't protect you and they won't protect you. Your passport is evidence that when you are outside of your country where you're from, your government is protecting you. So if you are an asylee or a refugee and you ask for your passport, you're basically saying, oh, I can trust my government to protect me again. So you shouldn't do that if you're an asylee or refugee. What people, especially asylees and refugees, should do, if they're here in the U.S., they should look into if they're eligible for lawful permanent residency. If, when that's going to happen, if they're eligible now, certainly once they get their green card, they'll, like I said, you have more rights. They'll be better protected under the laws. They should try to bring their family members here. If you are approved for asylum status, there's a process to legally bring derivative family members, so spouse and minor children, legally, obviously. So should look into doing that. If you need to speak to an immigration attorney, obviously that's a good idea. And then this applies to really every non-citizen who's got a work permit, an employment authorization document. Look into when your work permit expires, and we're saying that you should look into filing it about 6 months before your card expires. Now that DHS has said they're not going to process renewals within 90 days, it could take much longer. You don't want a lapse in your employment authorization. As the employer, you certainly don't want to be faced with this question of laying off your employee, or obviously you don't want to employ them illegally. So, they should be very careful about the expiry of their documents.
And, from the employer side, it's certainly a best practice to be tracking the expiration date of your employee's employment authorization because the employee may not be aware of this recent change, which says that the EAD will no longer be guaranteed processing in 90 days, or they may just forget. So, if you want to be able to continue to benefit from their services, we certainly recommend that all of our employer clients independently keep track of work authorization end dates so that they can also give the employees a nudge about renewing them.
This last point, and I'm sure that many of you are facing these questions from your employees now. What other things that would be useful to know about immigrant staff members? People are really freaked out and they're really scared. Even people who have green cards, they might not be sure if they're going to be subject to enforcement. They may have friends or family members who they're worried are subject to enforcement. So I think that tensions are running very high right now. Especially people who either have temporary status, don't have status, people who are from the 7 affected countries. I think that the restaurant industry sees a lot of immigrants, in all sorts of positions within the restaurant industry. And so this, I think, that is something affecting you all on the phone, perhaps more than other industries. Something to remind you that there is this heightened enforcement for this quote-unquote criminal aliens. So people who have been arrested and have pending charges, these are people who are going to be subject to enforcement. These are people who are extremely vulnerable. So again, they're going to want to talk to and consult with both Criminal Defense Counsel and Immigration Counsel to make sure whatever the outcome of these criminal charges are, that they'll be able to hopefully maintain their immigration status or keep their status. And then this last point, we talked about these 287G agreements. The local law enforcement is now deputized to quote-unquote enforce immigration law. There, you'll see, and you may have been hearing about in the news, there are sweeps, there are raids. They're picking up lots of people, even if they're only looking for one person. If they catch a bunch of other people in their net, they're picking them all up. This could happen at your restaurant. This could happen near your home. This is happening around the country. So it's a new America here. But one thing, if you have an employee who you know to be an immigrant and they don't show up for work and you're worried maybe about what happened to them, there is a online locator. So I have the link down there, the ICE detainee locator. I usually just Google ICE detainee locator and that website comes up. If you know their A number, their alien number, which will be listed on their green card or on their employment authorization document, their place of birth, their birthday, that's the type of information this database asks for. And if they're being detained by ICE, their name will come up and you'll see where they're detained. So if you have an employee who just doesn't show up for a couple days and it's not like them, that would be a good place to take a look.
Okay, thank you, Rachel. So let's talk next about the different type of enforcement actions that employers might encounter. So there are 3 primary types of enforcement actions that you might expect to see. The first are ICE raids. So this is, I think, what we've been talking about so far is Immigrations and Customs Enforcement showing up at your restaurant, asking everybody for their papers. It's the most dramatic type of raid, and when you talk about immigration enforcement, I think this is what everyone thinks of. There are also 2 other types of enforcement actions, which we frankly see a lot more of. The second type are I-9 audits. So as you know, all employers are required to complete a Form I-9 to verify employment eligibility for all workers. And we've had numerous clients who've been audited by Homeland Security investigations, which is part of ICE. They do not show up at your workplace with, their guns drawn. They send you a notice. They ask you to provide your I-9 documents. They come and pick them up. They take them away. They review them. It takes quite some time, usually a year or longer, and so it's a process, still quite burdensome if you're an employer, but not quite as dramatic as an ICE raid. And then the last type of enforcement action would be a site visit. So this would be relevant for employers who have sponsored non-immigrant workers. The biggest category would be H-1Bs. So our law firm does quite a lot of H-1Bs for workers in the restaurant industry. I'm not sure how widely used this visa is throughout the industry, but certainly any restaurant that uses the H-1B visa can expect to be visited by FDNS, which is part of the USCIS. We have seen these site visits throughout various types of employers, including a large global law firm where I used to work. One of my paralegals was on an H-1B. They came to visit the law firm to make sure that he had the proper documents. We've had restaurant employers visited really throughout any industry, and the current administration has announced that they would like to expand site visits ultimately to all types of visas, so we can definitely expect more site visits.
Before we go to the rates, I just want to put a parenthesis here. I think it's in between the two sections of the presentation, but it's not related to immigration. But I know it was we had quite an impact in Washington, D.C., and I would imagine in certain cities as well. And that's when your employee doesn't show up because now they're participating on immigration-related demonstrations. I know that's something that we got several questions. So if it is not because they were picked up or anything, if you know that some demonstrations are going to take place and some of your employees are going to participate, it's okay to find out, to ask them whether they're going to be participating and whether they plan not to show up to work following day or the day of the demonstration, to be able to make arrangements for that. What I would counsel people to do is, and again, it's up to you, but what I would ask you to do is not try to either encourage them or discourage them from participating in these events. And I would encourage you to talk to an attorney before you take any action, because in addition to immigration law, there are some issues related to labor law, and they may have a right under the National Labor Relations Act to stop work and to go into these demonstrations. So again, if you know of them, they're usually reported in the media. You might know because your employees tell you about it. Feel free to ask them if they plan to participate, to make arrangements to cover those positions, but be very careful before taking any other employment action. It doesn't mean that they're authorized or not authorized to work, or it doesn't mean, it could mean a number of things. Make sure that you talk to an attorney before you take any negative action regarding one of those. Sorry, go ahead.
Definitely. No, that's an important point. So we have a question here relating to H-1Bs. So I brought up H-1Bs, and the question relates to H-1Bs and how long they last, and how can employers ensure that the employees go back to their home country. So the first and most important point is, I think there might be some confusion here between the H-1B and the H-2B. So the H-1B is a professional worker visa. We can get them sometimes for restaurant managers in large restaurants, certainly for office, like a human resources manager, a finance manager, again, in large restaurants. So they're professional jobs that require a bachelor's degree. Occasionally, we can also get them for managerial chefs, executive chefs, chef de cuisine, also in large restaurant groups where they have a lot of financial management and human resources management duties. But they're for jobs that require degrees. And the H-1B is available for an initial period of 3 years and can be extended for an additional period of 3 years, and sometimes beyond that. So if you have individuals in these high-level positions, the H-1B can be a good option. It also has it has pros and cons. The H-2B is a different visa. That is for a need that is temporary, seasonal, peak load, so short-term need, and generally those visas are available for a maximum of 10 months. They're used a lot by the skiing industry as an example, so industries that are seasonal, that need a lot of labor at one particular time of year. And so if you do have a need for a large workforce based on a season or a one-time need, that could be a good plan, but they're extremely burdensome, so they don't really make a lot of sense unless you're bringing over quite a lot of people. And, you know, to this point, we call it an alphabet soup. There are dozens of different types of visas, all that have their own letters assigned to them. I have a handy cheat sheet that I use, so I can either make it available through the National Restaurant Association. No, I will make it available through the National Restaurant Association so that you can see, you know, it's a one-pager and it explains the types of visas that are commonly used by the restaurant industry. Okay, so there's a really good website on RAID statistics, and I think this is actually the site that your Syracuse University seems to be engaging in a valiant effort to keep all sorts of immigration statistics. So that's a very interesting site. You can take a look at some of the numbers there. I think the most sort of important point for me when reading that was that the numbers are not necessarily a lot higher than they were, but I think there's been a lot of, because there's been so much media and a lot of rhetoric, there's certainly been a lot more concern, and they're sort of sweeping more broadly. So instead of targeting people more specifically, they're casting a wider net, and that certainly has caused more consternation amongst our clients.
I think that previously under the Obama administration, they would maybe detain lots of people, take a look at their documents, and ultimately exercise prosecutorial discretion and not put them in removal proceedings or enforce, perhaps old deportation orders. I think what we're seeing now is that this prosecutorial discretion is really is going to be very sparingly used now. So whereas lots of people were picked up probably in previous years and then let go and say, okay, well, you're not a priority for us, I think that we're going to see lots more people subject to enforcement, more than before.
So this talks about, I guess, was that last week? We're probably a little beyond that. Anyway, in the month of February, there have been increasing enforcement authorities, also conflicting rhetoric about what's going on. President Trump said that it did represent a crackdown. Immigration officials said it was just routine. I think time will tell. What the numbers will show what's actually going on, but what we can say as immigration lawyers is that we're certainly getting more calls about these issues. So this is what happens. There's a great article, which I think also the National Restaurant Association may be able to make available to you, which lays out in great, it's written by an immigration colleague of ours in California, and it lays out in great detail what happens in the event of a raid. So that, I think, is an excellent resource if you want to really understand the nuts and bolts of a raid. But basically, prior to conducting a raid, there's an investigation that goes on, and it might be targeted by the arrest of an employee. So, your employee gets arrested for drunk driving over the weekend. They ask where your employee works, and then they come to visit your work site. No match letters from the Social Security Administration. So particularly if your company has received a lot of no match letters, that could be a trigger for ICE to start investigating. An I-9 audit, which we'll get to in a minute, but if they come to visit you and they find that a lot of your LCAs that your I-9s are not compliant, that could trigger an ICE raid. And then the last one is an employee complaint. So based on this investigation, they would obtain a search warrant. And so this is what happens when they actually come to raid your company. They'll seal off the premises, and They will ask, they will demand that no one leaves the premises, and
Could you tell us what happens if they don't have a search warrant? Could you ask them to leave?
if they don't have a search warrant, I would imagine that you could ask them to leave, but I don't think that they would conduct it wouldn't be a raid if they just stopped by your place of business. I don't know, Rachel, whether you have ever seen that issue, but I have not had the experience of ICE stopping by without a search warrant.
I haven't heard of that. In the context of like visiting someone's home, we tell people that if they don't have a warrant, you don't have to let them into your home. If it's a business, I imagine if it's a private business, and a business owner would probably have the same right as a private citizen to say, this is my property, you don't have the right to be here. But I imagine that they would probably quickly turn around and go get a warrant.
Right.
So,
and that's a question that we have. I would say that they have counsel, they know what they're doing, and they would risk losing an entire case if they come in and do a search without a search warrant. And they do not want to be embarrassed in court as well. So it is possible that they could stop by, but my experience is that they have it. But
yeah.
I will add that unlike in federal court or in state court, in immigration court, the federal rules of evidence do not apply. So where you were saying, if they obtained evidence without a warrant or with an illegal warrant, not an effective search warrant, in other courts that would be inadmissible and it could ruin their whole case. In immigration court, they can use really whatever they can.
No, I know, but for the purpose of the employer would not be going to immigration court. We're concerned about all the other penalties that they will have to bring through a regular court. And again, if they want your records and they want other things, my experience is that they will do it properly and they will come with a search warrant. It actually gives them authorization to do much more than just ask you every time they want to.
Right. Well, and I would think that they wouldn't want to tip off their hand. I mean, once they have collected enough evidence against a business, they can execute a search warrant. So if they just stopped by, that would give the business advance and its employees advance notice. So I haven't heard of it happening, and I would think it would be unlikely that they would come without a warrant. And yes, the warrant would be served at the time of the raid. There was a question about, are we allowed to keep copies of immigration status documents? So I think that's a two-part question. So we'll get to I-9s in a minute, but for I-9 purposes, when you verify the employment authorization of your employees, you have a choice. You can either keep documentation for all employees or not keep documentation for any employees. So some employers prefer to keep the documentation and some employers don't, and it's really, we generally recommend keeping it, but there's not really a definitive answer one way or the other. The only really critical thing is that you don't do it in a discriminatory manner. So if you keep a document for anyone, you need to keep a document for everyone.
So I reiterate that point again, having worked so much on labor and workforce issues, you have to be in compliance with all laws, not just immigration law. So in this particular one, yes, either keep copies of some people, of all people, or no one, because if not, you might be opening yourself for liability under discrimination laws if you're only doing it for, let's say, foreigners or what have you. So be very careful. It's okay to have a policy, but then you have to adhere by it and do the same thing for everyone.
So once they've sealed off the exits, they will start questioning your employees. They will start looking through your documents and your electronic devices to see what relevant information they can find. They will ask the employees questions, and if the employee says that they're not a U.S. citizen, then the burden shifts to them. Of course, that doesn't mean the answer is to say you're a U.S. citizen if you're not a U.S. citizen, because that would cause you a world of hurt.
Yeah, definitely don't say you're a U.S. citizen if you're not a U.S. citizen. That's a big problem.
Yeah. But assuming that you are a U.S. citizen, stating that alone should be sufficient. But once you say you're not, then they'll start more detailed questioning.
But to go off of that, Becky, one of the things that is now recommended to on the employee side is that ICE can't start removal proceedings against you unless they can prove that you're a non-U.S. citizen. So you have the right to remain silent, and that's one of the things that is recommended for non-citizens is exercise that right. Don't admit that you're not a citizen. Certainly don't say you're a citizen if you're not, but don't admit that you're not a citizen. Just keep silent until you have the opportunity to have a lawyer present and help you.
Right, absolutely. There's a question here about whether the raids could take place during service hours, dinner or lunch service. Yes, the answer is unfortunately that could certainly happen and has happened in the past.
Probably when they would want to do it, because that's when all the employees are there.
Right, maximum impact. If the employees don't have their immigration documents, they would let either a family member bring them or HR provide them if they're available. The ICE agents might also interrogate the company employees. And I did want to share a news story that I read this weekend, which was a little alarming, which was about a gentleman who was born in Puerto Rico who was arrested on a criminal charge and then turned over to ICE, despite the fact that being born in Puerto Rico, as Angelo knows, he was a U.S. citizen. He was detained for 3 days by ICE. His mother brought his birth certificate. They asked him questions about Puerto Rico. He had immigrated to the mainland when he was 8 months old, and he was not able to...
You moved to the mainland. You don't immigrate from Puerto Rico.
Sorry. You're absolutely right. You are absolutely right. So you can see, even I get confused. In any event, they did not believe, they thought that his birth certificate was fake. They did not trust that he was actually a U.S.-born U.S. citizen, and it took them 3 days to straighten that out. So it's just a cautionary tale about, a heated environment that we're operating in. The next things that would happen would be that the agents would take an inventory of the people they arrest, the property they seize, and the employees who cannot prove legal status would be immediately arrested and taken to detention centers.
That might include people who exercise their right to remain silent. So just because they're keeping silent doesn't mean they won't be arrested. As Becky mentioned, they arrest U.S. citizens. So
right, exactly, but hopefully not a lot. So what should the company do? What should you, as the representative of the company, doing during a raid? So of course, we would say call your attorney as soon as possible. These raids last a while, so if your attorney is nearby, he or she may be able to arrive, fairly soon after the raid starts. Take a close look at the warrant to make sure that it's signed, that the time frame is correct, that they're not doing anything outside the scope of the warrant, and make sure that your attorney gets a copy of that. As for the name of the agent and the U.S. attorney that are assigned to the case, keep the press out. Your instinct might be to, if you feel you're being unfairly targeted or if they're disruptive, they come during service, you might want to talk to the press. Generally not recommended. If you work with a PR firm, you could certainly speak to them about what they think the best strategy is, but overall, from a legal perspective, we would recommend that you don't talk to the press and that you don't give statements to ICE agents or allow company representatives to be interrogated by ICE. You can follow them around while they're at your facility. You can write down what they're doing. You can take a video of what they're doing. You should inform your employees that they have a right to talk or to remain silent, but don't direct them to do either thing. Ultimately, the choice needs to be theirs. Does your attorney need to be an immigration attorney? I think the attorney certainly needs to be someone who's familiar with ICE raids, so that most likely would be an immigration attorney, and not all immigration attorneys would be familiar with ICE raids. So, I think it would be important it's possible that there are some criminal attorneys who might have experience with ICE raids, but you certainly should find out whether your attorney has experience with ICE raids, and if not, if you think that this, if you're concerned about this possibility for your restaurant, I would ask for a referral to an attorney who has experience with ICE raids now, just so you can keep that information handy in case you need it. So certainly you don't want to hide people. I hope that goes without saying, but shredding documents would also be bad form, helping people escape, providing false information. They have the right to break locks, so if you don't want them destroying, if you want minimal damage, you should provide them access to locked facilities. So these are some things that after a raid you can do to limit your liability. So the first is to secure separate counsel for the company itself, as well as any individual executives or managers of the company who are targeted. Sometimes the company might consult with a single attorney at first, but it is entirely possible that different individuals might have conflicting interests, and so it is important that each individual who needs representation has separate representation. You can also retain a private investigator to interview witnesses to get your own side of the story. A proactive step that you can take is to retain immigration counsel before a raid to make sure that you have a good immigration compliance program in place. And if you're replacing the workers who were targeted during the raid, you should certainly make sure that you replace them with people who are documented and authorized to work in the U.S. We had a client who was hoping they could just rehire the same people after a different type of audit, but unfortunately it doesn't work that way.
So we have two questions. Two persons have asked the same question, so let's see if we can address it now. How do you suggest if they come during working hours, how do you suggest restaurants address the customers?
That's a very good question. I mean, I think that's probably a question for your PR firm and not your attorney. I mean, they are the government. They have a legal right to be there. I don't know whether, I think that the customers would be detained in the restaurant with the employees. That's my understanding.
Yeah, I imagine if they're closing all the doors and asking everybody for their documents, they could even ask the customers for the documents too. I think that this kind of goes along with one of the other things that you said, Becky, is that as the restaurant owner or manager, you don't want to do anything that appears or is impeding ICE's ability to conduct this raid. So you certainly, I don't think that you have to facilitate it. You don't have to,
right.
Affirmatively ask all your customers to put their, passports on the tables. But, if people are curious, I think that, like Becky said, it's a PR question. Legally, you just want to not do anything that's going to impede their investigation. So,
and what I would say is, again, even I know from the term raid, and I know that I know of raids, particularly of ag and construction, where they actually come in and they do the rounding up. The raids that I have that I know about at restaurants, they did not come during the rush hour. It's not that they were closed, but they did not come during the rush hour, and it's a lot more civilized than you would imagine. They come in, they ask for the manager, they show the warrant, and there's some discussion. It's not, guns drawn and, everybody put your hands on the table. So it's so I'm not saying it's a situation that you would like to be in, right. But it's not, from what I know, unless things change, and things are changing. from what I know, they come in and it's more of a discussion, and they do try to work to a certain extent with the restaurant in order to be able to gather the information and be able to gather their information.
Yeah, and it's a very good question. I mean, I would hope that they would sort of interview the guests first before, and let them go before they interview the employees, but I don't actually know sort of procedurally what happens with the guests versus employees. Just a few other points. If you have several work sites, only one of them was rated, you should certainly audit your other work site internally, work site or work sites, to make sure that they're in compliance. Be sure to provide your counsel with a copy of any documents that were seized. And again, don't shred any documents. Don't advise anyone to provide false or misleading statements to investigators.
I have another question as well. Again, going back to labor law, which is whether you can ask somebody about their criminal background and then decide not to hire them based on that. The EEOC, the Equal Employment Opportunity Commission, has been deciding that, and this is the whole ban the box, if you may have heard that expression, that you cannot be asking people for the criminal background and disqualify them from certain positions if a violation has nothing to do with the job that this person has is applying for. I mean, if you have somebody that is being considered to work the cash register and they have theft, well, clearly, but if you're trying to hire somebody to be a dishwasher and they have a record of a DUI, one thing is not related to the other, and they might view that as discrimination, particularly if you're only asking the question from people that you think are immigrants or on other types of work visas. So again, it's not immigration law, but you got to be conscious of all the laws that we need to be in compliance with.
What if the raid is done on the weekend and no HR is available to provide documents? So, the individuals would either need to have a family member provide the documents, or I would imagine they would be taken into custody until HR or a family member is able to provide the documents. There was also another question about, what happens if the employee chooses to remain silent. So I think, it's most likely that employee would be arrested. I don't know, Rachel, what your opinion is. But
I agree. I think they will most likely be arrested and detained, since ICE is going to try to determine whether the person is a non-citizen. And if they're not able to confirm that, I think that they will arrest that person and until they can prove their citizenship. And I think, like Becky mentioned, there are people who are U.S. citizens who are getting caught up in this, either because ICE doesn't believe that their documents are real, which as what happened with this Puerto Rican man, or, a lot of times people have certain health or mental health issues that make it difficult for them to communicate or provide the right documentation. There's actually been a long and sad history of U.S. citizens getting caught up in this sort of thing. So.
And again, that's also not new law or only applies to immigration. If you get stopped, you can be a U.S. citizen, you got stopped driving without a license, and if they don't believe that you tell them you are who you say you are, they can hold you and detain you. You're technically not under arrest, but they can detain you until they figure out who you are. You don't have to say anything. You don't have to provide your license to a police officer, but they have a right to try to figure out who you are and what you're doing, where you're at. So if they decide not to talk, maybe they don't have any identifications, they will need to wait for a family member to bring and prove that you are who you are, which is clearly what happened to this individual.
Right. And I think Rachel's point earlier was that rather than saying something that you might later regret, it might be preferable to be arrested and spend the night in jail and, to consult with an attorney and to present, there might be a legal argument that you can present, but, if you speak off the cuff to an ICE officer, you might say something that could later be held against you. So it's certainly a strategic decision, but there could be reasons to remain silent, even if it means that you would be arrested. I don't know the answer to this question. Can we ask to make copy of the materials before they're seized? I suspect the answer is no. I think they are required to provide them to you after the fact, but I don't know that they would allow you to make copies in the course of a raid, but I don't know for sure.
Before we go on to the I-9 audits, I think we wanted to talk about what restaurant owners and managers can expect if there is a raid, what could happen to their staff if they're arrested. What used to happen is that if folks were arrested on immigration charges, they would be processed at the local ICE facility. And typically, if there was no serious criminal issues, they would be released after a few hours. If they start removal proceedings, they would typically receive a document saying they were in removal proceedings, and they would, for the most part, if they didn't have criminal issues, be able to be, not in jail, not detained, pending removal proceedings. It's unclear whether that process is going to continue, and actually from the implementation memos, it looks like there's going to be an increase in not only just enforcement, but detention pending removal proceedings. So I would say, the process will be someone's arrested, someone's processed by immigration. They could continue to be held, up until the point where they get, they could initially either be offered a bond by ICE, or ICE could not offer a bond and just detain them throughout removal proceedings. It could be, several weeks to a month, or even longer before the person has the chance, if they're detained, to get in front of a judge if ICE does not offer a bond. So it could be that the employee is away from your restaurant for several weeks until they get a chance to request a bond from an immigration judge. So I would say, if your employees are picked up, it could have a significant impact on your business. It could be a long period of time before the person's able to come back to work.
So there are a few questions before we talk about I-9 audits that we should address. The first was whether it would be appropriate for employers to give employees in advance the information we just discussed about what happens if they choose not to speak. So I think that's fine. One thing that I can recommend is that there are good resources, we'll get to them at the end of our presentation, about knowing your rights. There's actually a little wallet card that they can print out. Rachel will provide some information. One service that we offer is actually to do know your rights presentations for companies. So sometimes we'll go into a company and explain to employees, what might happen, what they can do, what they shouldn't do. I think providing your employees with information is a good idea, and there are various ways to disseminate that information to your employees.
I would suggest to, again, recommend that they talk to an attorney of their own. I would stay away from explaining what we're explaining to you now. They have the right to remain silent. They have the right to talk to the law enforcement. Remember that there may be a follow-up criminal investigation or criminal proceedings against the restaurants, and whatever you say, whatever they said that you told them, could be used against you as well. So unless you're an attorney and you're an immigration attorney and you want to counsel them, I would suggest that you let somebody else counsel that individual that would happen to be their client. Whatever conversation you have with them, whatever email you have with them, that is not protected. Whatever communication they have with an attorney will be protected communication. So that's another incentive to just, suggest that they contact someone else. And again, there's a lot of groups out there that provide that information for free to workers.
Yeah, and that's a very good point because, whatever you say could be taken out of context. And so I think, from a liability perspective, pointing them to resources that are already available is probably a safer idea.
I would say it's not a bad idea if you have staff who are not U.S. citizens to recommend that they speak to, a reputable immigration attorney in the event something happens, just so they have someone that they know, they have already talked to somebody about their status, they can feel a little bit more secure in their future. That way the restaurant, the employer, doesn't say anything that would open them up to liability, and they can, kind of help their staff be on the straight and narrow.
There was a question about no-match letters and the ACA no-match letters versus the the old style SSA no-match letters. So I have to admit I'm not an expert in this, although my practice does bump up against no-match letters from time to time. So I think it was probably about 10 years ago that the first rash of SSA no-match letters came out. And then about 1 year ago, we started getting contacted by people who were getting these ACA-triggered letters, which I think actually came from a different part of the government. But in essence, their effect is the same. So I would imagine that from the perspective of potentially triggering an audit or a raid, they would have the same effect.
And with no-match letters, I mean, no-match letters can come from DHS, Social Security Administration. They're different. And the experience that we have had is a lot of, in most occasions, by the time the no-match letter gets to the employer, and there's some no-match letters that are sent directly to the employee might not even be working, given the change that we have in our industry. They might not even be working at the site, so it's not the most reliable piece of evidence, to try to go to a restaurant. Right. Because, again, they might not even be there anymore.
There's a question regarding monetary fines. So we're going to get to monetary fines for I-9 audits in just a minute. I actually don't have the information about monetary fines for ICE raids. I can certainly see if I can find anything and provide that to the Restaurant Association, but I don't have information today about monetary fines. There's another question about whether ICE would be able to take your hard drive if your employee documentation is stored online, it's paperless. The answer to that question is certainly if there is relevant information that's covered by the warrant on your hard drive, they would be able to take it. If it's all in the cloud, I think that could raise interesting issues. It's not on your hard drive, but yes, I mean, they have the right to take your physical documents as well as electronic documents. So the second type of enforcement action, and this is what I in my immigration law practice have seen a lot more of, at least in past years. These are I-9 audits. So the IRCA, the Immigration Reform and Control Act of 1986, does a number of things, requires you to complete an I-9 for every worker, prohibits unlawful hiring, so you can't hire people who are not authorized to work. It sanctions employers who violate that, and it also prohibits discrimination, which can sometimes be a little bit of a catch-22 for employers in trying to collect enough documents but not too many documents. So there's a new I-9 that came out on November 14th. There's a link to it, so please be sure that you're using the most recent version. So you are required, as the employer, to review the first section of the form and look at the documents no later than 3 days after hire. You have to look at the originals. They have to appear genuine. So you're not expected to be a forensic scientist. You're not expected to be a document expert, but you are expected to make a good faith effort. If the photo ID is a different person's photo, if there are other obvious defects, as long as you've acted in good faith, you will be protected legally. And then what the employee must do is to provide either one document from List A, which could be, for example, a U.S. passport, which provides both work authorization and verifies identity, or one from List B and one from List C. So that could be like a driver's license and a birth certificate. So they have to prove identity and they have to prove work authorization, and they could prove that either by one or two documents. And this is important. This rule is a little confusing, but you have to keep the I-9 for the later of 3 years from the date of hire or 1 year from the date of termination. And we had a disastrous case in our practice where they got confused about this rule and they actually shredded a lot of I-9s that were still valid and then had to go back and ask the employees to represent documents, which was an issue in and of itself because that could be considered document abuse. So be sure to follow this rule for retention. So these are the penalties. We won't get into great detail here. Basically, you can be penalized for knowingly hiring someone who is unauthorized and also for continuing to employ them. The tiers are based on aggravating factors like was it your first time, what percentage of your workforce is not authorized, et cetera. And then this is for paperwork. So there's a separate set of fines for paperwork violations. So, for example, did you over-document? You collected both a passport and a driver's license. So that's too many documents, and you could be fined for that. If the employee didn't date the document, if you whited out something, you should never use whiteout on an I-9. So all of these technical violations are also finable, although at a lower level. Okay, and then you can see these are the factors. So the size of your business, whether you were found to act in good faith, how serious the violation is. Actually, unauthorized aliens, I'm not even sure what that means. And then your history of violations. So those are the factors that would be used to calculate the penalty. So this is what happens if you are audited. And I think I saw a question before about 3 business days. So in the case of an ICE raid, you don't get 3 business days, but in the case of an I-9 audit, you do get 3 business days. So that's why I said it's a little bit more civilized. It sounds like Angela has heard of some very civilized ICE raids too. I've heard a few anecdotes of uncivilized ICE raids, but I suppose there are both types of ICE raids. But anyway, overall, the I-9 audits proceed at a slower pace. So that actually gives you the opportunity to call your immigration counsel, have them come out during that 3-day period, take a look at the documents, see whether there are any errors that can be corrected. So even though, obviously in this context, you wouldn't want to shred documents or, replace documents with new documents, you would very visibly line out any errors and you would initial and date them. But if you make the effort in that 3-day period to correct any paperwork violations, that will certainly be a good reflection on you. It will also give you a sense of how many violations you have. So immigration counsel should be able to look at your I-9s and say, you have 300 I-9s and I only found 3 paperwork violations, so you're going to be totally fine. Or you have 300 I-9s and 150 of these documents are clearly not even really, real work authorization documents, you're going to have a problem. So that's important. This is just a flow chart of the I-9 inspection process. This talks about E-Verify. I think, Angela, the National Restaurant Association has taken a position about E-Verify. What's the latest about?
Yeah, we support the Legal Workforce Act, which mandates E-Verify nationwide, but it comes with a number of protections that if you use them in good faith, some of the penalties that you talked about will be, in essence, waived, particularly when we're talking about just paperwork, technical violations.
Absolutely.
So right now, most of our members, particularly chain restaurants, use them, but not all. And, of course, it's regional in nature. Some states are mandated, and in those states, all of them or whoever's required uses them. But again, it's a lot still happening in Congress before that becomes the law.
Absolutely. Well, and that actually, the reason we put the slide in here is that President Trump has indicated a desire to expand mandatory E-Verify, so I think we'll see more of it, and we do recommend it to our clients as a best practice.
So, Becky, I have a question. Let's say, like Angela said, a lot of our members are already voluntarily using E-Verify. What would you say or recommend for those who would decide or stop using it? Would that raise a red flag or in this environment?
I think it could. I think they would have to have I would have a good rationale if I were a business that was using it and stopped using it.
Stopped automatically.
Yeah, I mean, there could be a cost-based rationale, certainly, but I would document very well if I were to stop using it. Okay, so just quickly, I brought this up before. I see this as sort of a catch-22. So, you have to be very careful when completing the I-9 not to discriminate against employees. You cannot tell employees which documents to provide, and that can sometimes be frustrating, I can say, as an employer, because sometimes the employee looks at list A and B and C and doesn't really know what to provide. But you're not allowed to instruct employees specific documents. There have been incidents where, employers would be very lax about what, one set of employees provided, and then maybe for, Latino appearing employees, they would ask for more documents, and they were sued for discrimination. So just important to keep in mind that you must complete the I-9 in the same manner, and you cannot specify which documents you want to see. You can go ahead to the next slide. Okay, so these are just some good tools. The M274 is great. This goes over just about every I-9 scenario you could imagine. These are E-Verify, and the OSC Employer Info Hotline, that's for discrimination questions. So if you want to check a document but you're not sure whether that would count as discrimination, you could call the OSC Employer Hotline. Here's a question: should we keep copies of I-9 forms in a separate folder so we can facilitate the auditing process? Absolutely. You want to be in a position to hand over those. If you're audited, you want to hand over your I-9 files. You don't want to hand over those files. Do they audit only current employees? No. They audit. So we talked earlier about which I-9s you're required to keep. So the audit will include prior employees. And this is actually a very important point. So you should purge your I-9s every so often, and not keep I-9s that you're no longer required to keep, because if they come to your workplace and ask for your I-9s, you have to provide all the I-9s that you have, even if you would have legally been allowed to destroy those I-9s because you're no longer allowed to keep them. So if you had a paperwork violation on an I-9 for someone who quit 10 years ago, if you shred that before you get audited, that would be fine, but you can't shred it, and you could get fined for it after you're audited. There's a question here: if ICE agents go to your restaurant for a specific employee, can they then check other employees' documentation? I think it depends on why they're there, but as we discussed, normally if they're coming to your restaurant, that would be in the context of a raid, and they would have a warrant, and they would likely be coming to look at your whole operation and not just a specific employee. I don't know, Rachel, whether you've ever seen that.
Typically, if they come looking for one person but they find lots of other people, they will pick up everyone. That happened in the bad old days before President Obama revisited his priority efforts, and that is what we're hearing now is happening. That they'll go looking for one person who maybe have some criminal charges and they may be after, but they'll pick up everyone.
Okay. There is a question here. It's a long question. I'll just read it. So, have you found that when this would be ICE audits an employer and the employer negotiates a time frame with those who are unauthorized to work, for instance, pay a fine, and continues to employ an individual for a certain number of days, are you finding they're re-auditing employers if the employer has now implemented E-Verify after receiving the initial audit? So I can tell you that my experience with ICE in the context of I-9 audits is that they have been pretty reasonable. So they will negotiate with employers about, it's not that they come in and they find that, you have 100 undocumented workers out of a workforce of 300 and you have to terminate all of those immediately. Although, it generally, they'll allow you to space it out over a period of several months. I mean, not a really long time, but, in the cases that I've worked on, there have been maybe, 3 to 6 month time frame during which they allowed the employees to replace their workforce. Let's really quickly talk about site visits. I suspect that this will not impact as many employers as the other two categories, but it is important for any employers who sponsor non-immigrant workers. So if you have someone who has asylum status, you haven't sponsored them, that's something they apply for on their own. There are other statuses that employees can obtain without your assistance. But if you sponsor somebody for a J1, an H-2B, an H-1B, an O-1, an E-2, those are just some of the types of visas that our clients sponsor. You can expect that you could be audited by fraud detection and national security. And in a nutshell, when you sponsor an employer, you tell the government what job the person's going to fill, what work site they're going to be at, how much you're going to pay them. And so when they audit you, they come to make sure that you're doing what you said you would do. So let's skip through the rest of that. There is some information about what happens in an FDNS audit if you're interested. I guess we have about 15 minutes left, and so Rachel's going to talk a little bit about how to communicate, what to communicate, how to communicate with your employees, and then we'll talk about a few upcoming things. And we've been doing our best to answer the questions as we go along, so but we will, continue to answer questions until the end.
Yeah, I think that we, in our slide here, what to tell your employees, I think we addressed most of these issues already throughout the presentation. Carry valid immigration documents. If you have a valid immigration document, you should carry it and you should show it when you face an encounter with immigration. Certainly, like I mentioned before, if there's concern, the employee can exercise their right to remain silent. They can refuse to show certain documents. Certainly, if they're arrested, they're going to look at the documents, eventually as pursuant to that arrest. But, and I've told my clients before, perhaps you don't want to carry your passport if that's an admission of your alienage. You're not a U.S. citizen. But if you've got, like Becky said earlier, if you are a green card holder, you're supposed, you have to carry your green card with you. So be sure to do that. I think we mentioned this before. They have a right to remain silent, but you can't tell them not to talk to ICE agents because that's obstructing justice. So don't do that. They have, inform your employees they have a right to speak to an attorney. It's a good idea that they speak to one sooner rather than later. It's a lot easier to talk to a lawyer when you're not detained. So, be proactive and make sure that, the immigration situation is copacetic. If your employees are non-citizens and they have children, they can tell ICE agents that they have little children, and ICE, like I said, they can exercise discretion when they're deciding how long to detain someone, but that is not something that I would bank on if I were the employee. I've seen a lot of ICE agents be pretty, they don't really care about that anymore. So, but, your employees can, and I always recommend, and we hand out at our office these little Know Your Rights cards. The ILRC, they're really backlogged, but they typically, if you can order a bunch of them for free, they'll send them to you. People can carry them with them. They're in English and Spanish. Best practices of what you should do in case you're confronted with an ICE raid or encountering ICE officials. Many folks may be employing people who have DACA, the Deferred Action for Childhood Arrivals beneficiaries, or sometimes called dreamers. So people have been in the United States since they were pretty young kids under the age of 15 who've been here since at least 2007, they do have work authorization. They're already screened by U.S. immigration authorities to be determined they don't have any sort of serious criminal records, or really mostly any criminal records at all. It's rumored that President Trump may be looking to do away with this program. in the memos that are out now and in the implementation memos that are out now, DACA has not been touched, and that is yet. There's a leaked executive order saying that that President Trump is looking to terminate programs like DACA. That hasn't been published. It's just rumors, and it could be that they're, running it through council, running it through their legal branch to see if that's what they want to do. If they do terminate DACA, there is congressional support from both sides of the aisle to have some sort of fix for these types of individuals. So if you do employ DACA beneficiaries, not all hope is lost for them right now. They're fine right now. So, and they should also, like we said, look into seeing if they're eligible for other more permanent forms of immigration relief. That would be better for them because DACA certainly is not permanent and can be taken away any second.
There are a few outstanding questions here that we should address. One, I think, should I move all my employee documents to the cloud? I'm not sure that there would be a legal benefit to doing that. Certainly from an organizational standpoint, you might be in a better position to find them if, just as an example on the FDNS site visits, when I prepare employers for site visits, the first thing I always ask them is, do you have a copy of the petition you filed for this person? And half the time they say yes, and half the time I say no. And then, I tell them, okay, I'm going to send you a copy of the petition. Make sure that you save it in a place where you can easily find it and, where any other managers would be able to find it if FDNS showed up at your door. So, if your paper documents are not well organized and you think that it would be difficult to find them, then I think this could be beneficial, but I don't have a recommendation really from a legal standpoint. And the other question I think is also an employment law question. If an employee is picked up, how long are you expected to hold their job while they're being investigated? I don't know that there's any obligation. Do you have any idea, Angela, to hold a job for someone?
No, there's no obligation to hold. You got to look at any state law, but at least in an at-will state, you do not. All I would say also is don't jump into conclusions, particularly during the first executive order. People with green cards were not allowed re-entry. So if you knew that one of your employees was not allowed re-entry, that didn't mean that the person didn't have work authorization. That was just the chaos that came with the order.
And there are certainly, people who have valid work authorization can still be subject to removal proceedings, and it doesn't necessarily affect their work authorization. So, be wary of terminating people just because of their immigration status. If they have valid work authorization, that's not going to be a legal basis to terminate them.
Okay, and then we have on the next slide, this is a draft executive order that was leaked. Now, there were a lot of things that were leaked. We don't really know if and when. Unlike the travel ban, where the administration has said numerous times that it's going to be released, imminently, this one was released was leaked, and I haven't really seen much more about it. So I don't know if and when it will be implemented, but when it is, or if it is, it will prioritize U.S. workers, and what they want to do is to have the relevant departments review all federal laws that relate to the employment of foreign nationals in the U.S., which are a lot of, that's probably more than a 4-year project right there. So, but I think that, they do want to do a comprehensive review of the laws and regulations, and so we could expect some sweeping changes if this executive order goes into effect. As we talked about in the site visit section of the presentation, this is the order that would ask for increased site visits in various categories, so not just the H-1B where they're currently doing them. They will look at other categories such as B-1, which is the visa for business visitors, E-2, which is a visa for investors, F-1 OPT, which is for students who have completed a degree, H-1B, which is the professional worker visa, J-1 summer work travel for foreign college students, L1, which is for multinational managers, and also EADs, which are general employment authorization documents. And then the final point about this order is that it encourages increased participation in E-Verify, which we also touched upon. So last but not least, what can you do? So maybe Angela wants to speak about this.
I just want to put a plug there for a public affairs conference. It's coming up March 28th and 29th. You can register online. That's the website. You can go to restaurant.org/PA conference. We have a number of issues that we want to go and lobby on, but immigration is one of them, and you can come with your state delegation and provide have more impact. After that, you have the contact information for Becky and Rachel at Hammond Young and Grossman Law. If you have any, we've been saying a lot to contact your immigration attorney, so that's what I suggest you do. And particularly if you want to send them one way, they have a restaurant, they can go to Becky if it is for your employees, because you shouldn't have the same person representing both sides. It makes even more sense to send them to Grossman Law. There's a lot of things that are changing, so I would encourage you all to keep up with the website. You can also contact, you want to go to the next slide? Shannon Mead, she works on the policy side, and she can give you more information on the public affairs conference, and she's going to be available doing visits as well. Or you can contact me at the Restaurant Law Center. There's a lot of changes continuing to come up. We have a long-standing relationship with Becky and now Rachel, so we're going to put other materials on our website on some of the visas that we talked about. So with that, we kept it to 2 hours. This is the longest we have had a webinar, but I thought there's so many things going on that we thought 2 hours was appropriate. So everyone, thank you for participating.